Welcome to the deep dive. Today we're stepping right onto a major fault line in medical practice.
It's a really significant one, yeah.
It's a fault line that every medical student, every junior doctor, and honestly even senior clinicians need to completely understand.
Absolutely.
Not just to pass your medical legal exams, but to actually safely navigate your entire career. So think about standard clinical practice for a second. When you're on the wards, your primary allegiance is incredibly clear.
Right, it's to the patient.
Exactly. It is to the patient sitting right in front of you. You're guided by beneficence, by non-maleficence, and a strict code of confidentiality. But the moment you step into the realm of forensic and legal medicine, the ground beneath you just shifts completely.
It's a total paradigm shift.
You might suddenly find yourself instructed by the police or the courts, maybe insurers or even professional regulators. The terrain moves from therapeutic to investigative, and it forces you to ask a very uncomfortable, really complex question. Who exactly is the client here, and what is my duty?
It's a profound shift in perspective. And frankly, it's where so many practitioners, even incredibly experienced consultants, can find themselves stumbling into real danger.
Because the lines get blurred.
Exactly.
Yeah.
When you blur the lines between being a treating physician and a forensic investigator, you open yourself up to massive ethical and legal liabilities. Ethics in this context is not some abstract, dusty philosophy discussed in a first-year lecture hall. It is practical integrity in action.
Yeah.
It dictates how you obtain consent, how you structure your reports, and how you maintain your professional independence when, say, a police officer is standing right over your shoulder asking for immediate results. If we connect this to the bigger picture, ethical clarity is the absolute only thing that prevents role confusion. It protects the rights of the individual being examined. And crucially, it maintains the public's fragile trust in the medical profession as a whole.
Okay, let's unpack this, because to map out these ethical and medical legal foundations properly, our mission for this deep dive is going to be strictly defined.
You need boundaries for this.
Right. We are acting as your high-yield, memory-anchored revision tool. We're pulling all of our material directly and exclusively from Chapter 2 of Simpson's Forensic Medicine. We aren't bringing in outside opinions. We are sticking to the definitive text.
Which is exactly what you need for exams.
Exactly. We're going to walk through the evolution of medical ethics, the specific duties of doctors, the absolute minefields of confidentiality and consent, and finally, professional regulation. What actually happens when things go wrong and you face a fitness to practice panel?
It's a lot of ground to cover.
It is. So whether you are listening on your commute, cramming for exams, or just trying to survive your next rotation, we have got you covered. We aren't just going to read you lists. We are going to build clear conceptual frameworks. And Chapter 2 doesn't start in a modern courtroom. It starts by taking us way back to the origins of Western medicine to understand where these rules even came from.
It does, and that's a really necessary starting point. It's important to recognize right off the bat that healthcare has incredibly diverse global backgrounds. You have traditional Chinese medicine, Ayurvedic medicine in India, and incredibly complex systems across Africa and the Americas.
Right, it's the global history.
But our focus today, guided strictly by Simpson's, is on science-based Western medicine. And the roots of that specific system trace back to ancient Greece. Although even calling it purely Greek is a bit of a historical simplification.
Because it pulled from everywhere.
Yeah, Greek medicine was itself a synthesis of knowledge gathered from Asia, North Africa, and Europe. But it all really coalesced around the Hippocratic school on the island of Kos, roughly around 400 BC. That specific location and time period is where the foundations of both the practice of medicine and its ethical facets were firmly laid down.
Right, the Hippocratic Oath. I mean,
Yeah.
It's the one piece of medical history everyone in the general public has heard of.
Oh, definitely.
But reading the actual translated text provided in Simpsons is kind of wild. It is not just a simple "first do no harm" bumper sticker. There are some incredibly specific and frankly surprising stipulations in there that paint a picture of a very different medical landscape.
It's very much of its time.
For instance, the original oath explicitly says, "I will not use the knife, not even on sufferers with the stone, but will leave this to be done by men who are practitioners of this work." Basically, you have ancient physicians swearing they absolutely won't do surgery, specifically refusing to remove kidney or bladder stones, leaving that bloody work to the barber surgeon.
Wow.
It also includes promises not to administer poison or a pessary to produce an abortion. And there's a very strict vow to abstain from the seduction of patients, quote, free men or slaves. It is a fascinating window into the specific societal problems and hierarchies of 400 BC.
It truly is. The oath is a mirror reflecting the risks and the social structures of its era. Surgery back then was incredibly dangerous. It lacked anesthesia, it lacked antisepsis, and the mortality rate was catastrophic. So physicians actively distanced themselves from it to protect their professional reputation and, theoretically, their patients.
That makes total sense.
And the mention of free men and slaves obviously reflects the stark social hierarchy of ancient Greece. But while much of that specific granular detail is completely obsolete for a modern practitioner, the oath has endured through millennia because of its underlying common sense. However, before we move on, we need to bust a very persistent myth right here.
Oh, about taking the oath.
Yes, it is commonly believed by the public, and even by some medical students, that all doctors take the Hippocratic Oath when they graduate. In the UK, a doctor is defined as a medical practitioner registered by the General Medical Council. And the reality is, taking the oath is not a universal requirement for GMC registration. Nope. Some do take a version of it, but it entirely depends on the tradition of the specific medical school they attended.
I always find that surprising. So if the specific wording is mostly obsolete, we obviously do surgery now, and not everyone even takes it upon graduation, why does a modern textbook like Simpson's dedicate valuable space to it? Why should a junior doctor care about what guys in togas were doing on the island of Kos?
Because the core framework it established is still the absolute bedrock of everything we are going to talk about today. The specific words about bladder stones have faded, but the underlying principles have not.
The core pillars.
Exactly. The oath established the absolute necessity of confidentiality swearing to keep secret what you see or hear in the course of treatment. It established non-maleficence, the vow to use treatment to help the sick, and never with a view to injury or wrongdoing. And it established strict professional boundaries, hence the rules against seduction or exploiting the vulnerable.
So confidentiality, non-maleficence, and boundaries.
Yes. Those three pillars are the direct ancestors of modern medical ethics. They have evolved, they've been influenced by society, by common law, and by the profession itself over 2,000 years, but the ethical DNA is identical.
Which brings up a really interesting transition because those ancient principles didn't just naturally gradually shift into modern codified rules, they were forced to evolve.
Through tragedy, mostly.
Right. Moving into the next section of Simpsons, we look at international codes of medical ethics. And this evolution was a direct, urgent response to some of the absolute darkest moments in human history. We are talking about the foundation of the World Medical Association, the WMA, in 1947.
The timing of that foundation is the critical context here. 1947 is the immediate raw aftermath of the Second World War. The international medical community was reeling from the horrific, systemic violations of medical ethics that occurred during the war.
The experiments.
Yes, specifically the brutal, non-consensual human experimentation and atrocities committed by credentialed doctors in Nazi Germany and Imperial Japan. The global profession realized that vague, ancient oaths and localized gentlemen's agreements were no longer sufficient. They had failed entirely.
So they needed a global standard.
The profession needed global, unambiguous, ironclad policy statements on ethical behavior, patient care, and human research.
And their first major act was the Declaration of Geneva in 1948, which the textbook notes was most recently amended in 2006. Simpsons describes this as the modern restatement of the Hippocratic Oath.
It really is.
When you read the pledges in the Geneva Declaration, you can still hear those echoes of Kos, but with a sharp, legally minded, modern edge. Two lines from the text really stand out to me. First, the health of my patient will be my first consideration. And second, which clearly points directly back to the horrors of World War II, I will not use my medical knowledge to violate human rights and civil liberties, even under threat.
That phrase, even under threat, carries an immense burden. It completely removes the defense of, I was just following orders. It places the ultimate ethical responsibility directly onto the individual physician's conscience.
You can't pass the buck.
Exactly. If a regime demands you use your medical skills to facilitate torture or oppression, the WMA dictates that you must refuse, regardless of the personal cost. And from that foundational Declaration of Geneva, the WMA started tackling specific, highly complex global issues. For those of you listening who are prepping for exams, you need to develop pattern recognition for these key WMA declarations because they map out the vast scope of global medical ethics. Let's create some memory anchors based on the specific table provided in the chapter.
Let's do it. I love a good memory anchor.
Okay, first, think of the incredibly complex world of research and human experimentation. That entire field is governed by the Declaration of Helsinki, originally drafted in 1964. If you're doing clinical trials anywhere in the world, Helsinki is your ethical rulebook.
Helsinki equals research trials. Got it.
Second, consider the absolute prohibition on medical involvement in torture and cruel, inhuman, or degrading treatment. That is the Declaration of Tokyo from 1975.
Tokyo equals torture prohibition.
Third, the ethical and highly sensitive considerations around therapeutic abortion. That was addressed in the Declaration of Oslo first in 1970 and revised in 1983.
Oslo for therapeutic abortion.
And jumping much closer to the present day, think about the ethical nightmare of modern technology, massive health databases, biobanks, and big data. The ethics of how we use, store, and share vast amounts of patient data is governed by the Declaration of Taipei from 2016.
So, Helsinki for trials, Tokyo for torture, Oslo for abortion, Taipei for data. That is incredibly helpful for keeping them straight in a multiple-choice scenario. Now, alongside these specific declarations, the WMA also explicitly breaks down the duties of a physician into 3 broad tiers.
They do, and it provides a great structural overview. First, you have duties in general. This demands that as a physician, you must always exercise independent professional judgment. You cannot allow your clinical judgment to be influenced by personal profit or unfair discrimination.
Makes sense.
It also states you must certify only that which you have personally verified. You can't just sign off on a colleague's assessment without checking it yourself. Second, you have duties to patients. This requires complete loyalty to the patient. It demands that you respect a patient's right to confidentiality.
But there are limits to that, right?
Yes. The WMA explicitly notes a crucial exception. Confidentiality can be ethically breached if there is a real and imminent threat of harm to the patient or to others. It also strictly forbids entering into a sexual relationship with a current patient, echoing that ancient boundary from Kosas.
And the third tier.
Finally, there are duties to colleagues. You must not undermine the patient-physician relationship of a colleague just to attract patients to your own practice. And you must communicate effectively and respectfully with colleagues involved in the care of the same patient.
Okay, so that's the global high-level view. But I have to ask, how does this actually translate to the ground? How do these lofty international WMA declarations filter down to a junior doctor working a chaotic Tuesday night shift in a hospital in the UK?
That's where the national regulators step in.
Right, which brings us to our third section of Simpsons, the modern practitioner's blueprint. We are transitioning from the global WMA to the national regulatory framework. In the UK, that means the General Medical Council, the GMC, and their core definitive guidance document, Good Medical Practice.
Good medical practice is the absolute rulebook for registered doctors in the UK. The GMC outlines 4 rigid domains that every single doctor must meet to maintain their license to practice. If you are taking notes or just trying to internalize your professional responsibilities, these are the 4 pillars of your daily existence.
Domain 1.
Domain 1 is knowledge, skills, and performance. This isn't just about passing your exams and being smart. It is about recognizing the limits of your competence. It means knowing when to ask a senior for help and committing to keeping your skills up to date throughout your entire career.
Right. And Domain 2.
Domain 2 is safety and quality. This requires you to take prompt action if you think patient safety, dignity, or comfort is being compromised. It means you are a safeguard for the public. If you see a colleague practicing dangerously, you have a duty to speak up.
Domain 3 is communication, partnership, and teamwork. This covers treating patients politely, respecting their right to confidentiality, listening to their concerns, and working effectively with the wider multidisciplinary team.
Exactly.
And Domain 4 is maintaining trust. This means being honest, acting with absolute integrity, and never discriminating unfairly. Sid Simpsons makes a really crucial point about the specific language used in the Good Medical Practice document. It's not just a casual read. You need to understand the medical legal wording.
This raises an important question of legal interpretation, and it's a vital distinction for both clinical practice and for your exams. When you read GMC guidance, you must pay intense attention to the verbs.
The musts and shoulds.
Precisely. When the guidance says you must, that denotes an overriding duty or principle. It is non-negotiable. If you fail to do something that the GMC says you must do, you are in immediate breach of your professional standards.
You can't argue your way out of a must.
No. However, when the guidance says you should, it means they're providing an explanation of how you will generally meet that overriding duty, or it implies that the specific duty might be context-dependent and won't necessarily apply in every single complex clinical situation. Knowing the difference between a must and a should is often the difference between a defensible clinical decision and finding yourself facing a fitness to practice hearing.
Here's where it gets really interesting, or rather, really legally dangerous if you weren't careful. The chapter dives deep into a major medical legal trap that catches a lot of practitioners off guard: intimate examinations.
Yes, this is a huge area of risk.
The GMC receives a significant number of complaints every year from patients who feel doctors have behaved inappropriately or unprofessionally during these exams. And Simpson's defines an intimate examination quite broadly. It is a visual assessment or physical examination that involves touching an intimate area by hand. This obviously includes breasts, genitalia, and the rectum.
Obvious ones.
But the text explicitly notes it could include any examination where it is necessary to touch, or even just be very close to the patient, depending on the patient's cultural background or personal trauma history.
Because of the incredibly high risk of misinterpretation or accusation, the documentation discipline required here is absolute. You cannot just casually perform the exam. You must follow a rigid defensive protocol.
Step 1.
First, you must clearly explain to the patient exactly why the exam is necessary and what it will physically involve, including any potential pain or discomfort. Second, you must get explicit permission. Third, and this is the crucial safeguard, you must offer a chaperone.
A chaperone. Who exactly counts as a chaperone?
A chaperone should ideally be an impartial observer, usually a trained health professional like a nurse or a healthcare assistant, not just a relative or a friend of the patient who might not know what a standard medical exam should actually look like.
Wait, let me challenge you on that, though. What if you are in a busy A&E, you offer the chaperone, and the patient just waves you off? They say, look, I'm fine, doctor. I trust you. Let's just get this over with. I don't need a chaperone. Can you just proceed?
You can proceed, but that is exactly where your documentation discipline saves your career. You must record in the contemporaneous medical notes that the clear offer of a chaperone was made and that the patient explicitly declined it.
If it's not in the notes, it didn't happen.
Exactly. If a chaperone is present, you must record their specific identity in the notes. Furthermore, you must provide privacy for dressing and undressing, use drapes appropriately, and absolutely avoid any unnecessary personal comments or small talk that could be misconstrued. And perhaps the most absolute, unbreakable rule of all: if at any point during the examination the patient asks you to stop or shows clear signs of acute distress, you stop immediately.
Right, then and there.
There's no arguing, no saying, just one more second, I'm almost done. You stop.
It's about protecting the patient's dignity, but equally, it's about protecting the practitioner from baseless allegations that can end a career. Now, the chapter doesn't just focus on doctors. It rightfully expands the lens to other healthcare professionals who have increasingly important independent roles, especially in forensic settings.
Very true.
We're talking about paramedics assessing detainees in police custody or sexual assault nurse examiners conducting highly sensitive forensic exams.
Exactly, and those allied professionals are held to equally rigorous statutory standards by their own regulatory bodies. For nurses and midwives in the UK, the regulatory body is the Nursing and Midwifery Council, the NMC.
And what's their core code?
Their foundational code is structured around 4 core themes: prioritize people, practice effectively, preserve safety, and promote professionalism and trust. For other allied health professionals, and this is a massive group, including paramedics, dietitians, clinical scientists, radiographers, and operating department practitioners, they're regulated by the Health and Care Professions Council, the HCPC.
And the text points out that the HCPC has real teeth. It legally protects specific professional titles. So it is actually a criminal offense for someone to falsely claim to be a registered paramedic or a registered dietitian if they aren't fully accredited and on the HCPC register.
It's all about public protection. When a vulnerable patient sees someone wearing a badge that says paramedic or using the title dietitian, they need absolute, legally backed assurance that the person standing in front of them meets the statutory standards for training, clinical skills, and ethical behavior. You can't just have someone calling themselves a nutritionist confusing the public with a protected title like dietitian.
To wrap up this section on the practitioner's blueprint, the text brings up the classic 4 pillars of medical ethics. These are the broad, abstract concepts that underpin all the incredibly specific practical rules we just discussed. First, autonomy, the patient's fundamental right to refuse or choose their own treatment.
Right.
Second, non-maleficence, the duty to do no harm. Third, beneficence, the duty to act in the patient's best interests. And fourth, just as how healthcare and limited resources are apportioned fairly across society.
And we see these 4 pillars applied formally in systems like the NHS Health Research Authority, which governs research ethics committees across the UK. Their entire mandate is to protect the rights, safety, dignity, and well-being of human research participants. Essentially, they are institutionalizing the concepts of non-maleficence and autonomy in the highly complex realm of medical research, ensuring we never repeat the mistakes that led to the WMA declarations in the first place.
Which flows seamlessly into our fourth section. And this is perhaps the most critical conceptual framework for a forensic practitioner, navigating confidentiality.
Vault.
Yes, I like to think of confidentiality as a highly secure vault. The entire doctor-patient relationship is built on the profound trust that what goes into that vault stays there. Without that trust, patients simply won't tell you the truth. If a detainee in police custody is struggling with a severe hidden alcohol dependency, but they think telling you will somehow end up in a police report and impact their impending court case, they will lie to you.
Of course they will.
And if they lie, you can't assess them safely or treat them effectively.
That is the exact clinical and ethical rationale. Confidentiality is a primary duty, but, and this is the vital, nuanced distinction the GMC makes clear, it is not an absolute duty.
It has limits.
It does. There are specific, legally defined times when that vault must be opened. In England and Wales, institutions have senior personnel designated as Caldecott guardians. These are usually senior doctors or nurses who are specifically responsible for protecting patient data and enabling appropriate lawful information sharing. Furthermore, any handling of personal data must strictly comply with the overarching federal laws, the General Data Protection Regulations, the GDPR, and the Data Protection Act 2018.
So no leaving charts lying around.
Exactly. Leaving paper records visible on a clinic desk, discussing a case in a crowded lift, or sharing a computer password isn't just sloppy professional practice. It is a literal breach of data protection law.
So let's get into the mechanics of this. When does the vault legally open? When does confidentiality not apply? The textbook provides a fantastic, clear, conceptual framework breaking down the 4 statutory keys to the vault. Let's go through them methodically because this is where practitioners get into trouble. The first key is when disclosure is required by law.
This is where statute strips away your clinical discretion entirely. The law mandates disclosure, whether you or the patient want it or not. For example, in the UK, there is a mandatory legal requirement for regulated professionals to report known or suspected cases of female genital mutilation in girls under 18.
And infectious diseases, right?
Yes. Another massive area of mandatory reporting is the statutory notification of infectious diseases. Registered medical practitioners in England and Wales have a strict legal duty to notify a proper officer of the local authority, which is often the consultant in communicable disease control, about specific dangerous diseases.
Like what, specifically?
The textbook provides a brilliant illustrative example of a Public Health England report. If you diagnose a patient with cholera, measles, rabies, tuberculosis, or anthrax, you do not sit down and ask the patient for their permission to share that information. You are legally required to notify the authorities immediately to prompt local investigation and control the public spread.
And courts can order it too.
Furthermore, under this same key, courts and judges have a legal power to order the disclosure of medical records if they deem them materially relevant to a case. If a judge issues a court order, your duty of confidentiality is overridden by the court.
The second key is with consent. This is obviously the most common everyday way information is shared. It can be implicit consent, like sharing a patient's lab results with the nursing team caring for them on the ward, or it must be explicit.
Express consent.
Right. Express explicit consent is absolutely required if you are disclosing information for purposes outside of direct clinical care or local clinical audit. If an insurance company wants a medical report, or a financial auditor wants to review records, or the police want a statement about a victim's injuries, you must have the patient's explicit, informed consent.
And anonymization is key here.
Yeah, the text makes a strong practical point here. Anonymization is always preferred. Even when you have consent, you should only disclose the absolute minimum necessary identifiable information required for the task.
The third key is where things get incredibly complex, and it is the critical forensic crossover. Disclosure in the public interest. Now, the GMC recognizes that confidential medical care is, in and of itself, strongly in the public interest. We want people to seek help. But sometimes the benefit to society or to a specific individual vastly outweighs the patient's right to privacy. This key applies when disclosure is justified to protect individuals or society from risks of serious harm.
This is the one that always feels subjective. Let's put this to a stress test. What does public interest actually look like in practice? If a patient confesses to stealing a candy bar, I assume we don't breach confidentiality.
No, absolutely not. The threshold is serious harm. So what does that look like? It means reporting concerns about a patient's fitness to drive to the licensing agency, the DVLA, if the patient is medically unfit, say, they have poorly controlled epilepsy, and they continue to drive against your explicit medical advice, putting the public at risk.
That makes sense. What about violent crimes?
It means reporting violent injuries like knife and firearm wounds to the police because the presence of a weapon is a public danger. It means reporting serious communicable diseases if the patient actively refuses to modify behavior that puts others at risk. And crucially, for forensic work, it applies to the prevention or prosecution of serious crime.
Like abuse or murder.
Exactly. If you believe a vulnerable patient is the victim of neglect or physical, sexual, or emotional abuse, or if a patient in custody casually confesses to a serious crime like an unsolved murder or child abuse, the public interest in preventing further severe harm or ensuring justice for a severe crime completely overrides their right to confidentiality. You must inform the appropriate bodies, like the police or safeguarding teams.
That is a massive, heavy burden to carry, deciding when that threshold is met. And finally, the fourth key, disclosing without capacity or after death.
If a living patient lacks the capacity to consent, perhaps they are unconscious in the ICU or have severe advanced dementia, you could disclose information if it is of overall benefit to them and in their best interests. This usually involves consulting with those close to the patient, like family members or legally appointed deputies, to gather context.
And after they die.
After a patient dies, your duty of confidentiality actually continues. It doesn't die with them. However, information must be disclosed to a coroner in England and Wales or the procurator fiscal in Scotland, which are the legal authorities responsible for investigating sudden, unnatural, or unexplained deaths to assist with their inquests or fatal accident inquiries. You also have to fulfill statutory rights of access to records by the deceased's family or legal representatives, provided that disclosure doesn't contradict the known, previously stated wishes of the deceased person.
So document everything.
In all of these situations, across all four keys, the documentation discipline must be flawless. Record your decision-making process, record your legal justification, inform the patient you are breaching confidentiality if it is practically possible and safe to do so, and disclose only the absolute minimum necessary information to achieve the goal.
Required by law, with consent, in the public interest, and without capacity. It's a robust framework. And that naturally leads us into our fifth section, because you can't talk about the with consent key without diving deeply into what consent actually means. We are moving to consent and capacity, and we absolutely have to start here with the most seismic, ground-shaking legal shift in recent medical history regarding informed consent.
Oh, the Bolam shift.
Yes. For decades, the gold standard in the UK for deciding if a doctor had properly obtained consent was something called the Bolam test, which stemmed from a case way back in 1957.
Yes, Bolam v. Friern Hospital Management Committee. For nearly 60 years, the Bolam test ruled the wards. It asked a very simple and highly protective question to determine if a doctor had breached their legal duty of care regarding consent. Did the doctor act in a way that is supported by a responsible body of medical professionals?
The reasonable doctor standard.
Exactly. It was essentially the reasonable doctor standard. If you as a doctor didn't warn a patient about a specific, perhaps rare side effect of a surgery, and the patient sued you, all you had to do was find a group of other reputable doctors who would say, yeah, we wouldn't have warned them about that either. If you could prove that a responsible body of your peers agreed with your decision, you were legally protected. It was a highly paternalistic approach. It literally enshrined the concept of doctor knows best into common law.
It protected the profession, but it left patients in the dark. But then came the paradigm shift. In 2015, the Supreme Court handed down a landmark ruling in Montgomery v. Lanarkshire Health Board. I think it's worth taking a second to look at the facts of that case because they are heartbreaking, and they explain why the law had to change.
It's a tragic case.
Nadine Montgomery was a pregnant woman, small in stature, and she was an insulin-dependent diabetic. Because of her diabetes, her baby was likely to be larger than average. This combination creates a known specific risk during vaginal delivery called shoulder dystocia, where the baby's shoulders get stuck.
Exactly. Yep. And the doctor treating her knew about this risk. It was about a 9 to 10% statistical risk, but decided not to discuss it with Mrs. Montgomery. Nor did she discuss the alternative option of an elective cesarean section. The doctor reasoned that if she told diabetic women about the risk of shoulder dystocia, they would all opt for C-sections, which the doctor felt was not in their best interests. Tragically, during delivery, shoulder dystocia did occur. The baby was deprived of oxygen and born with severe disabilities. Mrs. Montgomery sued, arguing that if she had been told of the risk, she would have absolutely chosen a C-section.
Under the old Bolam test, the doctor won the early rounds in court because other obstetricians agreed they also wouldn't have warned her, fearing a spike in C-sections. But the Supreme Court finally looked at this and said no more. They legally dismantled the era of doctor knows best paternalism.
Montgomery completely changed the landscape of medical law. The Supreme Court ruled definitively that the Bolam test no longer applies to the issue of advice and consent. The new test of materiality shifted the focus entirely away from the reasonable doctor to the reasonable patient. The law now states that doctors must ensure patients are aware of any material risks involved in a proposed treatment, and they must be informed of any reasonable alternatives.
So what exactly makes a risk material? How does a junior doctor know what to say?
The Supreme Court defined it beautifully and broadly. A risk is material if, in the circumstances of the particular case, a reasonable person in the patient's position would be likely to attach significance to it. But it goes further. A risk is also material if the doctor should reasonably be aware that the particular patient sitting in front of them would be likely to attach significance to it.
So it's personalized.
It means you can't just rattle off statistical percentages like a robot. A 1% risk of permanent stiffness in a finger might be statistically immaterial to most people. But if your patient tells you they are a professional concert pianist, that 1% risk is massively material to their life and livelihood. You have to know your patient. You have to work in partnership with them. It shifted consent from a signature on a form to a dialogue.
So practically speaking, how is this consent actually given on the wards or in a forensic suite? The text distinguishes between implicit and written express consent. Implicit is simple enough. You explain you need to take their blood pressure, then they hold out their arm and roll up their sleeve. Their physical action implies consent. But when do we cross the line and need it formally in writing?
Written consent is not just about generating a piece of paper for the file. It is about proving that a complex, Montgomery-compliant discussion actually occurred. It is generally accepted and often mandatory for high-risk or complex surgical procedures, for fertility treatments, and for participation in research. But let's look at the forensic context, which is vital for our listeners.
Right.
Simpsons explicitly states you should absolutely get written consent if providing clinical care is not the primary purpose of your medical investigation. Consider a forensic physician taking intimate penile or vaginal swabs from a suspect in a police custody suite for DNA analysis. In that scenario, clinical care is not the primary purpose. Gathering evidence for the police is. Because the environment is inherently coercive written, express consent is absolutely critical to prove that the subject fully understood what was happening and voluntarily agreed to the evidence gathering without undue pressure.
That makes perfect sense. Now let's talk about the concept of age and capacity. When does a person actually have the legal capacity to give this complex consent? The general rule in the UK is that those aged 16 and older are presumed in law to have capacity. But what about children under 16? This is a huge area for pediatricians and GPs. The text brings up two massive legal precedents here: Gillett competency and the Fraser guidelines. They get confused all the time. Let's break those down.
They do get conflated, but they are distinct. Both terms stem from a landmark 1980s legal battle, Gillick v. West Norfolk and Wisbech Area Health Authority. Victoria Gillick was a mother who took the health authority to court, arguing that doctors should not be allowed to prescribe contraception to girls under 16 without their parents' knowledge and consent.
And what did the court say?
The case went all the way to the House of Lords. The Lords ruled against her, establishing that parental right yields to the child's right to make their own decisions when the child reaches a sufficient understanding and intelligence. This broad concept became known as Gillick competency. The test is general. Can this specific child make a reasonable assessment of the advantages and disadvantages of the proposed treatment? Age isn't the sole determining factor. Maturity, intelligence, and understanding are. A 14-year-old might be Gillick competent to consent to asthma treatment, but not to complex heart surgery.
So that's Gillick, the broad concept of a child's maturity to consent. What about the Fraser guidelines? How are they different?
The Fraser guidelines are highly specific. Lord Fraser, in his judgment on that exact same case, set out specific guidelines that apply only to the provision of contraceptive advice and treatment for under 16s. For a doctor to lawfully prescribe contraception to a child under 16 without parental consent, they must be satisfied of 5 very specific criteria.
What are they?
1. The girl understands the doctor's advice. 2. The doctor cannot persuade her to inform her parents or allow the doctor to inform them. 3. She is very likely to begin or continue having sexual intercourse with or without the contraceptive treatment. 4. Unless she receives the contraceptive treatment, her physical or mental health, or both, are likely to suffer. And 5. Her best interests require the doctor to give her the advice or treatment without parental consent.
Let's boundary test that because it sounds strict. Let's say a 14-year-old comes into the clinic asking for the contraceptive pill. She meets criteria 2 through 5. She won't tell her parents, she's sexually active, she'd suffer mentally from a pregnancy, and it's in her best interests. But when you explain the pill, she completely refuses to listen to the side effects or understand the risks of deep vein thrombosis. She fails criterion 1. Does the whole thing fall apart?
Yes, the guidelines are conjunctive. All 5 criteria must be met. If she cannot understand the medical advice and the risks associated with the treatment, she does not meet the first criterion of the freezer guidelines, and you cannot lawfully prescribe the contraception without parental involvement. It highlights how these aren't just tick box exercises. They require deep clinical assessment of understanding.
Okay, that is a phenomenal framework to have memorized. Now, what about the other end of the spectrum? Adults over 16 who clearly lack the capacity to make decisions. Maybe they have severe advanced dementia, traumatic brain injury from a crash, or they are highly intoxicated in a police custody suite. In England and Wales, this entire area is governed by the Mental Capacity Act 2005.
The Mental Capacity Act, or MCA, is an incredibly empowering and vital piece of legislation. It rests on a few fundamental statutory assumptions that every clinician must internalize. First, you must assume every person has capacity unless it is explicitly proven otherwise. You cannot just look at someone with a severe learning disability or someone who is elderly and confused and jump to the assumption that they lack capacity.
Right.
Second, an unwise decision does not automatically mean a person lacks capacity. People are legally allowed to make bad choices. If a capacitous patient wants to refuse life-saving antibiotics because they'd rather go home to their dog, they can. Third, capacity is decision-specific and time-specific. A patient with early-stage dementia might lack the complex capacity to manage their financial portfolio or sell a house, but they might perfectly possess the capacity to choose what they want for dinner or whether they consent to a routine blood test, and their capacity might fluctuate. A detainee might be entirely incapable while highly intoxicated at 2 a.m., but fully capable of consenting to an exam the next morning when sober.
So how do we actually test it when we are in doubt? The text outlines a strict 2-stage test under the MCA. Let's walk through it. Stage 1 is diagnostic. Is there an impairment of or disturbance in the functioning of the person's mind or brain? This could be a permanent illness like dementia, a temporary injury like a concussion, or the effects of drugs and alcohol. Stage 2 is functional. Does that specific impairment mean the person is unable to make a specific decision when they need to make it?
In that second stage, the functional test is the core of the assessment. It is determined by 4 absolute requirements. To have capacity to make a decision, the patient must be able to do 4 distinct things.
Number 1.
1. Understand the information relevant to the decision, including the reasonably foreseeable consequences of deciding one way or another. 2. Retain that information long enough to make the choice. If they forget what you said 30 seconds later, they can't decide. 3. Weigh up the advantages and disadvantages. They must be able to use the information as part of a rational decision-making process. And 4. Communicate their decision by any means necessary, whether that's talking, using sign language, squeezing a hand, or even blinking.
So what you're saying is if a patient is completely lucid, understands the surgery, retains the info, and can communicate, but because of a severe psychiatric delusion, they absolutely cannot weigh up the reality of the risks. Say they believe they are immortal, they fail the test.
Precisely. If a patient fails on any one of those 4 functional points, understand, retain, weigh up, communicate, due to the impairment identified in stage 1, they lack legal capacity for that specific decision at that specific time. And if they lack capacity, the MCA dictates that you must act in their best interests, taking into account the views of those close to them, their past wishes, and always using the least restrictive option available for their care.
Understand, retain, weigh up, communicate. That is high-yield gold for anyone listening. Okay, we've covered the rules. We've covered the WMA declarations, the GMC guidance, the exceptions to confidentiality, and the complexities of consent. But what happens when the rules are broken? What happens when things go tragically wrong? That brings us to our final section, regulation and fitness to practice. We touched on the GMC earlier, but let's look at their ultimate power. The Medical Act 1983 gives the GMC their core legal mandate. And it's a mandate that often surprises doctors. It isn't to protect doctors or act as a union. The Act states, the main objective of the General Counsel in exercising their functions is to protect, promote, and maintain the health and safety of the public. They hold the keys to the medical register.
And if a doctor fails to meet the standards expected of them in good medical practice, the GMC is legally obligated to act to protect the public. The textbook walks us carefully through the structural flow of a fitness to practice, or FTP, complaint. It is a rigorous, multi-stage, highly stressful legal process for the doctor involved. It starts with the investigation stage. A complaint is received from a patient, an employer, or the police. The case is assessed, and evidence is gathered. This can take months and involves gathering expert medical reports, witness statements, and sometimes health assessments of the doctor. At the end of this lengthy stage, the entire case file is reviewed by 2 case examiners. Crucially, by law, one examiner must be medical and one must be non-medical, ensuring a balanced, public-facing perspective.
So what power do those case examiners actually have at that stage?
They have a few options based on the evidence. They can take no further action if they decide the complaint is unfounded or doesn't amount to impaired fitness to practice. They can issue a formal warning, which is serious. It stays on the doctor's public record for 5 years and is visible to all future employers. They can agree on undertakings with the doctor. This happens if the doctor accepts their practice is impaired, perhaps due to a health issue or a specific skills gap, and agrees to restrictions, like not doing a certain procedure or undergoing mandatory retraining. But if the case is complex, serious, or the doctor disputes the facts, the case examiner is referred onward to a full adjudication panel.
But wait, these investigations can take over a year. What if the doctor is accused of something horrific or is severely impaired by addiction and is in immediate danger to patients while this lengthy investigation is slowly happening?
That is exactly where the Interim Orders Tribunal comes in. This is operated by the Medical Practitioners Tribunal Service, or MPTS. If a doctor faces allegations so severe that it is absolutely necessary for the protection of patients or in the public interest to restrain their practice immediately, this tribunal steps in. They don't decide if the doctor is guilty, they just assess the immediate risk. They have the power to suspend a doctor's registration entirely or impose strict conditions on their practice for a maximum period of 18 months while the GMC investigation runs its course. It is a protective legal holding pattern.
And then comes the final stage if the case is referred, the adjudication stage, the fitness to practice panel. This is the stuff of nightmares for medical professionals.
Yes. This is a formal public hearing. It operates and feels very much like a court of law. You have a panel, usually made up of 3 people, a mix of medical and non-medical members. You have a legal assessor present to advise the panel on points of law. The GMC is represented by a barrister prosecuting the case, and the doctor is usually legally represented by their defense union. Witnesses are called, cross-examined under oath, and evidence is debated. The panel has to decide 2 distinct things. First, are the facts of the allegation actually proven on the balance of probabilities? And second, if the facts are proven, does that mean the doctor's fitness to practice is currently impaired?
If they find that fitness to practice is impaired, they have a sliding scale of sanctions. They could theoretically decide to take no further action, though that's rare. They can place strict conditions on the doctor's registration for up to 3 years. They can suspend the doctor from practicing for up to 12 months, but they also hold the ultimate professional penalty, erasure from the medical register, striking the doctor off entirely. And Simpson's notes a grim reality. A doctor who is erased can only apply for restoration to the register after a minimum of 5 years have passed. For many, it is a permanent career-ending event.
Before we look at a specific, deeply impactful case study, we have to mention another crucial regulatory requirement that was born directly from systemic tragedy. The textbook highlights the statutory professional duty of candor. This emerged directly from the public inquiry into the Mid-Staffordshire NHS Trust, where there were massive systemic failures in basic healthcare that led to patient deaths, followed by a deeply ingrained cover-up culture. The duty of candor makes it a strict legal and professional obligation to be open and honest with patients or their families when things go wrong and they suffer harm. You must explain exactly what happened, offer a genuine apology, and explain what the institution is doing to fix the error and prevent it from happening again.
Now, bringing all of this together, we've talked about regulation, systemic failure, personal culpability, and the public trust. The textbook dedicates significant space to one specific, highly emotive case where all of these forces violently collided. The 2018 case of Dr. Hadiza Bawagarba, this case sent absolute shockwaves through the medical profession, not just in the UK, but globally. It fundamentally altered how doctors view their regulators. Let's carefully trace the timeline of what happened here because the nuances matter.
What's fascinating here is how the legal and regulatory systems struggle to weigh a single doctor's actions against the weight of a broken hospital system. It is a profoundly tragic case at its core. Dr. Bawagarba was a pediatric registrar. Following the tragic death of a 6-year-old boy named Jack Adcock from sepsis, she was convicted in a criminal court of gross negligence manslaughter. Now, the crucial context, the context that terrifies every doctor, is that the hospital on that specific day was suffering from severe, objectively recognized systemic failings. There were massive IT failures preventing the review of lab results, extreme nursing and medical understaffing, and a critical lack of senior consultant cover. Dr. Bawagarba absolutely made clinical errors that day, but she was operating within a deeply broken, unsafe system.
So she receives a criminal conviction for manslaughter. The GMC's fitness to practice process then inevitably kicks in. The case goes to the Medical Practitioners Tribunal Service, the MPTS panel. The tribunal looks at everything. They look at the criminal conviction, the tragic death of the child, but they also carefully examine the horrific systemic hospital conditions she was forced to work under, and they make a decision. They decide to suspend her registration for 12 months. They felt that the ultimate penalty of erasure was disproportionate given the overwhelming systemic context.
But then, the extraordinary happened. The GMC, the regulatory body itself, appealed the decision of its own independent tribunal. They took the case to the High Court. The GMC argued a point of pure public policy. They argued that because a jury had convicted her of gross negligence manslaughter, meaning her conduct was deemed truly exceptionally bad by a criminal standard, public confidence in the medical profession could not possibly be maintained by anything less than striking her off the register. The High Court listened, and they agreed with the GMC. They ruled the MPTS was wrong to heavily weigh the systemic failings of the hospital against her personal criminal culpability. The High Court quashed the 12-month suspension and erased Dr. Bawagarba from the medical register.
And the medical community absolutely erupted. Doctors felt that if systemic failures were simply ignored by the courts and individual doctors were made absolute isolated scapegoats for underfunded, dangerous hospital environments, then literally no one was safe. It terrified the profession into defensive practice. So, supported by massive crowdfunding from other doctors, Dr. Bawagarba appealed the High Court's decision to the Court of Appeal.
And in August 2018, the Court of Appeal handed down their final decision. They unanimously overturned the High Court. They ruled that the original MPTS tribunal was legally correct to consider the systemic failings and the context of her chaotic working environment when deciding her professional sanction. The Court of Appeal set aside the erasure and restored the original 12-month suspension. This case is heavily featured in Simpsons because it perfectly crystallizes the intense, ongoing friction between personal culpability, the reality of systemic healthcare failure, and the overarching mandate to protect the public's trust in the profession. It shows that professional regulation is rarely black and white. It is fought out in the very gray areas of human fallibility and intense institutional pressure.
It is a deeply sobering case to study, and it highlights just how high the stakes are every time you put on a stethoscope or sign a document. We have covered a massive amount of ground today, pulling exclusively from the frameworks in Chapter 2 of Simpsons, from the ancient island of Kos to the modern Court of Appeal. But as we wrap up this deep dive, there's one final provocative thought that strikes me. Throughout this entire chapter, as we mapped out these rigid legal frameworks, the consent rules, the WMA declarations, one underlying tension remains completely unresolved by any textbook. And that is the psychological and emotional toll on the practitioner.
It's massive.
Think about it. You go to medical school driven by an innate, intensely trained desire to heal people, to fix broken things, to advocate for the person in pain. But when you step into a forensic role, say examining a victim of assault or a suspect in custody, your legal duty often requires you to suppress that therapeutic instinct entirely. You are asked to simply observe, document, and report an objective, sometimes devastating finding to a court, knowing full well your report might send someone to prison or take away their children. How does a forensic physician compartmentalize that? It is a psychological boundary that requires just as much rigorous maintenance, if not more, than the legal boundaries we've discussed.
That is a profound observation, and it cuts to the heart of forensic work. The shift from an empathetic healer to an impartial, objective investigator is not a natural transition for most clinicians. It requires a fundamental, conscious rewiring of your professional identity in that specific moment. And maintaining that emotional neutrality while still treating the subject with the basic human dignity required by the WMA and the GMC is the true unwritten art of forensic medicine.
Okay, before we officially sign off, let's do a rapid-fire stress test on these concepts to make sure they stick. We've built the frameworks. Now let's see if you can apply them. I'm going to throw 6 rapid single best answer style clinical scenarios at you, the expert, but I want the listener at home or on the ward to try and beat you to the answer. Ready? First scenario.
Ready? Let's do this. Question 1. You are a junior doctor performing an intimate examination in a busy clinical setting. You offer the patient a chaperone, as required, but the patient explicitly declines, stating they are comfortable proceeding without one and want to get it over with. What is your most immediate ethical and medico-legal obligation before you even touch the patient?
Take a second to think about your answer.
You must record in the contemporaneous medical notes that the clear offer of a chaperone was made and that it was explicitly declined by the patient. Documenting that refusal is your only defense. If the listener missed that, they need to revisit the section on duties of doctors and GMC guidelines regarding intimate exams.
Spot on. Ready for question 2.
Question 2. We are looking at the Mental Capacity Act 2005. Assuming an impairment of the mind or brain exists, stage 1 is meting. What are the 4 specific functional abilities a patient must demonstrate to prove they have the capacity to make a particular decision?
Do you have all 4?
The 4 pillars of the functional test. The patient must be able to 1. Understand the information, 2. Retain the information, 3. Weigh up the advantages and disadvantages, and 4. Communicate their decision. To consolidate this, review the section on patients without capacity to make decisions.
Excellent. Question 3.
Question 3. Which landmark 2015 Supreme Court legal case fundamentally shifted the standard of informed consent away from the paternalistic reasonable doctor standard, the old Bolam test, to focus instead on the reasonable patient and the disclosure of material risks?
This one is huge.
That is the case of Montgomery v. Lanarkshire Health Board, a total paradigm shift in medical law. If you need to review the shift in consent, head straight to the consent section of Chapter 2.
Question 4.
Question 4. And this is a tricky forensic crossover. You are a forensic medical examiner. A patient in police custody casually confesses to a recent unsolved murder during your routine medical assessment. They immediately remind you of your professional duty of confidentiality. Do you breach confidentiality to inform the police?
Think carefully about the threshold.
Yes, you absolutely do. Disclosure without consent is legally justified in the public interest to prevent or prosecute serious crime and to protect society from risks of serious harm. Murder easily meets that threshold. Revisit the section on confidentiality, specifically the key regarding disclosure in the public interest.
Question 5.
Question 5. Let's test those strict guidelines. Under the Fraser Guidelines, a doctor can lawfully prescribe contraception to a girl under the age of 16 without parental consent, provided they are satisfied of 5 specific conjunctive criteria. Name at least 2 of these key criteria.
Just need 2 of them.
I'll list all 5. The girl must understand the advice. The doctor cannot persuade her to inform her parents. She is likely to have intercourse anyway. Her physical or mental health will suffer without the contraception, and it is overall in her best interest to receive the treatment without parental consent. To review those, look at the section on young people, children, and consent.
Perfect. Final question. Question 6.
Question 6. We are in the GMC fitness to practice procedures. If an immediate and severe risk to patient safety is identified during the early investigation stage, which specific legal body has the power to temporarily suspend the doctor for up to 18 months while the lengthy investigation continues?
Lock in your answer.
That protective power belongs to the Interim Orders Tribunal, which operates under the Medical Practitioner Tribunal Service, or MPTS. If you missed the structural flow of how regulation works, revisit the legal framework for GMC fitness to practice procedures.
Excellent work. You nailed them. And hopefully our listeners did too. That brings us to the end of this incredibly dense, high-yield session. We strongly encourage you to pull out Chapter 2 of Simpson's Forensic Medicine and read it alongside this deep dive to truly cement the concepts and the medical legal wording we've discussed. Thank you for joining us on this rigorous exploration of the ethical fault lines of medicine. We wish you the absolutely best of luck on the wards, in the complex environment of the custody suites, and in your upcoming exams. Keep your integrity intact, document everything, and we will see you next time.